Yeah, so we did hear back from Alamo Heights. Apparently the video was destroyed. Deputy Chief Pruitt, thank you for coming in today.
So the only thing that has been purged is not the audio, it's the video for holding cell 1 and 2. The parties who are not here, we'll place them under subpoena.
It was a family second and he had the prior conviction. It started as a felony.
Okay, you need
and
to
it
slow
went,
down so the court reporter can keep up.
it started as a felony and then
So,
I will talk slower.
thank you. So I will tell you, what your mother said in that police report is the same thing that my mother always said to us and that my grandmother always said to them. I love you, but I'm not going to jail or prison for you.
Mr. Garvin comes strolling in at 9:25 a.m. Case is set for 9 a.m. Where you been? Excuse me? Home. Take him into custody, hold him, and then we'll make you think about being on time.
Okay, what is happening here? We were here last time, so there's supposed to be a possible video of an interrogation of Mr. Sanchez.
Yes, Your Honor, we still believe there is. The Alamo Heights Police Department responded that he was not interrogated and that they did not say there's not a video. They said, we've given you all the video. He was not interrogated. The facts indicate to us that he in fact was interrogated and there are cameras in the interrogation cell. So that's where we're at. I plan to issue a subpoena.
Okay, so they're saying they don't have a video?
They're saying well, they didn't say that. They said we've given you all the video.
Yes, Your Honor. So I emailed AHPD and what the detective emailed me back is the only video available is what was uploaded. The suspect was never interrogated. What we'd like to do, if we could, is get a setting for like a plea deadline setting, Judge, and give the defense counsel rather, time to subpoena any video from Alamo Heights PD.
All right, so you believe a video is in existence?
I believe my client when he tells me, Judge, that he was interrogated because he gave me some specifics. And I know that there's video in that cell. And I would be very surprised if there's no video taken of him. That would be very unusual. So I do believe there was.
All right, Ms. Ferguson. Yes, ma'am. On this case, give me a 3-week reset and that's your plea deadline date.
Okay. Judge, I'm going to subpoena those to the court on that day.
Okay. And have the officer come.
I am going to, Judge.
All right, thank you.
Have 2 of them here.
All right.
We may resolve the case in those. Okay.
August when? All right, August 7th. All right, so where are we on this? And counsel, you're on this side.
Sorry.
Where are we on this case?
Judge,
Was the video?
Yeah, so we did hear back from Alamo Heights. Apparently the video was destroyed.
Mhm.
There is audio, but it's incomprehensible.
Okay. So where are we on this case?
Well, Your Honor, I think that it's that I need to bring a motion to address that issue based on the destruction of the earth. I don't know if I can call it destruction, but based on the loss of the evidence, Judge.
Okay. All right, and when was the evidence destroyed?
Sorry, Judge, let me just pull up on my
Sure.
email here. So I think it's 76216.
I recall that initially they said they didn't have any recording devices.
Mhm.
And then we subpoenaed them, had a hearing. Your Honor was not present, but so we had it in front of a visiting judge. And they came and testified that the video was just destroyed.
I think it's like 911 calls are purged from their system after a certain amount of time. I believe that this the video is not of the incident that we're here today. It's after the defendant is in custody. It's a surveillance video of the holding cell, right?
Yes, where he
Yes.
was allegedly questioned by deputies.
All right, so with regards to the video on the holding cell, because this is a felon in possession of a firearm.
That's correct.
So how is that connected to the felon in possession of a firearm?
Well, Your Honor, it's not a direct connection, but without going into too much detail, there is allegedly a relative or Mr. Sanchez's boss was doing a construction project in Alamo Heights. The allegation that we would make verified allegation by Mr. Sanchez is that the Alamo Heights Police Department has a deputy who may no longer be working for him, but was at the time, who was sleeping with.
The thing is, the reason I want the video, the reason I wanted the video is because I was sitting in the holding.
All right, everyone, please whisper.
I was sitting in the holding cage. And when I'm sitting in the holding cage, because it's not a cell, I'm looking in their offices while he's processing all my stuff. And the commanding officer comes out and asks him, "Why'd you pull him over?" He says, "I put him over because I saw him and I felt like something was off." It's my understanding that's not probable cause. That's discrimination. So I was asking for the video so I could prove that. And then when I asked for the video, it's destroyed. I asked for it back in April. And
No, I know you asked for it in April, so I'm trying to figure out when this video was alleged to be destroyed, because if it was destroyed after April, then there's gonna be a problem.
Yes, ma'am. I have an email chain from this is from Ginger Liao, who's the administrative assistant for records for the Alamo Heights Police Department. So we requested, that was August, when defense made the request for the video.
April, I believe. And then we had to do a subpoena in August. Because
Alright. On Mr. Sanchez, we're gonna need to have a date for a hearing. And it should be fairly short. And one witness.
We can do September 28th.
All right, so we're gonna put it on September 28th for the hearing. And if somebody could also have that audio so that we can see if anything can be heard on the audio.
Yes, Judge. Do you want to hear from the officer too? I mean, while we're talking about.
Whoever you all want to call is okay with the court, and the court will hear the evidence.
Can we get both officers?
Sorry, what?
Can we get both officers, the commanding officer too?
Well,
I'll talk.
that'll be up to your defense counsel and who the state want to call, but my main issue and what this hearing is supposed to be about is about the video that I'm being told no longer is in existence. Okay?
All right, thank you.
All right, you're welcome. Think right. Yes.
Sorry to delay, Judge. We have a witness here from Alamo Heights. And, I think that's the move, is to bring her up first.
Yeah,
Or
Judge.
you have a motion too?
Well, by way of background, Judge, last time the court had
Set a hearing for a video
and
purge.
wanted to specifically know when that video was destroyed. So
Yes.
the state reached out and said, asked them that question. They sent 3 officers, including Detective Pruitt. I think it's a Detective Pruitt.
Yeah, I think it's
Deputy Chief Pruitt, none of which can answer the question. There is somebody that can. His name is Marcos. And asked him, well, why isn't Marcos here? And they said,
Well, let's find out.
they're not going to send him without a subpoena. That's what they said. So if she's here, I'd like to get that on the record.
All right, well, let's please do what we do.
Okay, so do you want to call Deputy Chief?
I guess so. Yeah.
Court is calling 2022 CR 10642, State of Texas versus Jose Sanchez. Could I have parties announced for the record for the state,
Hank Wilkins for the state.
defense?
Eric Baker for Mr. Sanchez, Your Honor.
And are you Mr. Sanchez? All right, the reason we are here is the defense alleges and your client alleges that there was a video in a holding cell of your client. And it is potentially Brady
Yes, Your
with regards to this case. Is that correct?
That's correct, Your Honor. Yes.
All right. State, are you prepared to proceed?
We are, Your Honor.
Defense, are you prepared?
Yes, Your Honor.
All right, state, do you have any witnesses?
Well, it's really, I guess more of a defense witness.
Yeah, Judge, I'll take this. I wouldn't mind taking the lead if the state's okay. And
All right. Who would you call?
we would call
Deputy Chief.
Deputy Chief Pruitt of the Alamo Heights Police Department.
All right. Deputy Chief, if you could raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I did.
All right, you can lower your hand. Just make sure you keep your voice up for the court reporter. If you could state your name for the record, please.
Cindy Pruitt.
All right, defense.
Thank you, Your Honor. Deputy Chief Pruitt, thank you for coming in today. So, Deputy Chief, the video that the court was talking about, you're aware of what video that we're talking about, correct? That we're looking for?
That's correct.
Okay. Now, before we get into that, I just want to ask you, When we initially asked for this video, we got word back from your department that there are no videos taken in that area of the department. Were you the one that conveyed that information to Mr. Wilkins?
No, I'm not sure what you mean. There are no videos taken.
So the first request to your office from Mr. Wilkins requested the video that we're talking about today. And my understanding is that your understanding that your office replied back that there was no videotape in existence. In fact, there was no videotape equipment to videotape at all. Was that your response from the office?
No, that wasn't my response. And in fact, I didn't respond to that. I'm not sure. Do you have the response you're
Okay,
questioning about?
the state has your email, but I'll move on. I wanted to know if you were aware of that.
All right, and counsel, so that the record can be clear, when you speak of video, what video are you talking
Yes,
about?
the video of Mr. Sanchez upon his arrest when he was in the holding cell or near the holding cell in Allen's Police Department. You aware of that video?
I'm aware that that video doesn't exist because it was purged from the system. Yes.
Okay, and one of the main question, this isn't our first time here, maybe your first time here, ma'am, is the court had a question, and I think I did too, as to when that video was destroyed. Or do you have personal knowledge as to what day it was destroyed?
No, we attempted to recover the video, but we don't have any way to determine when it was destroyed because it's a surveillance system that is on a loop. And as new video comes in, because it runs 24 hours a day, it's a very small server. The older video purges off and it just is replaced by the new videos.
You can't testify today as to when that video was purged, correct?
No, sir, I cannot. I can testify to the fact
That's just a
that,
yes or no question, ma'am.
no, sir.
Ma'am, I just talked to you in the back, correct?
Yes,
We talked about, asked you, is there anybody who can make that determination or tell the court? We spoke about someone named Marcos, correct?
that is correct.
And when I asked you, and you sent an email to Mr. Wilkins yesterday or 2 days ago, I'm sorry, no, yesterday and Wednesday, that he would not be,
Counsel, if you could slow down.
certainly, that he would not be in attendance today. Is that correct?
That is correct.
And when I asked you why back in the back, you said somebody made the decision that if he wasn't under subpoena, they weren't going to send him. Is that correct?
His leadership for his company made that decision, yes.
So he's really the witness we need to talk to today, not yourself, correct?
Well, there is his supervisor is available today by phone.
Can you come in?
I just found this out right before I came in here. They said they would make him available by phone.
Does he have knowledge of what we're looking for in the background so that we don't have to start over with him?
Yes, he has knowledge, yes.
Okay. When could he come in physically?
Oh, that I don't know. I didn't ask him.
Is he available to appear by Zoom?
I believe he's with an IT company that is our vendor.
All right, counsel, would you have any objections to him appearing by Zoom?
I would not, Judge. I just want to make sure that I know that Marcos has information. I'm just curious as to why we can't produce Marcos. His supervisor is going to be a level up. And Marcos has hands-on.
Well, is Marcos available to appear by Zoom, or does he want to
When I
subpoena?
spoke with his supervisor just a moment ago, Your Honor, he was directly involved with the process with Marcos. And he is a higher level IT technician than Marcos even is.
All right, so the defense wants Marcos here.
I
Is
think
that correct?
I think Marcos and his supervisor, Judge, just based on the history of this case, Your Honor. I mean,
All right, so I like to cut through the chase. Is Marcos and his supervisor available today by Zoom?
I would have to ask, Your Honor. I asked if they could be available by phone and he gave me his phone number and said that he was. I didn't ask about Zoom.
All right, does anyone mind us taking a short break so she can see if they're available by Zoom?
Not at all.
Thank you so much. Right. And Deputy Chief, what are the results of your inquiry?
Their HR department is denying them showing up on Zoom. And they said that because they were asked to do a task, they completed the task and they recorded all of the information on the ticket, which was then emailed. That's the only involvement that they have.
All right, well, if you will let them know, they can appear by Zoom or they can be subpoenaed, which means,
Should advise them of that, Your Honor.
all right,
Do you have any objection to me submitting this to the court? This is.
Actually, I was gonna, no, not at all. In fact, I was gonna submit that, Judge. There's an email chain that I think is gonna be.
All right, do you all want to remark it? And then I'll accept it.
Do you want to make it your exhibit or?
Joint exhibit.
I said if they mark it and offer it into evidence, I'll accept it. If there is no objection.
No, Your Honor. In fact, I was gonna offer that.
All right, if you could do it as Defense Exhibit 1. Thank you for trying. I know it's not your fault.
Yes, ma'am.
Your Honor, defense would offer Defense Exhibit 1. The state actually just provided to me. It's an email chain from August 14th through the present, correct?
August, it might be, I'm sorry, can I see it for a moment?
All right, just 1 second. Excuse me. If you all are behind the court reporter, if you all could move your conversation and move the inmates this way, that way it's not behind her. All right, you may continue.
Did they tell you how far back that those videos are saved on the server from that particular camera?
They said when they started looking after our request to see if they could locate the videos only existed back to March 12th, 2023.
2023, okay. And the date of offense is in 2022.
That's correct.
Okay. And so have you made a diligent search for these videos once you were notified by the Bear County DA's office that we were looking for any additional videos?
Yes, sir, we did. We, like I said, we reached out to our IT provider and requested their assistance in trying to recover any purged videos.
Okay. And so I've spoken to Ginger Leal, one of y'all's employees and she,
Oh, Hank, could you speak up?
oh, yes, ma'am. Sorry, Diana. When I spoke to Miss Leal, she looped you into that email chain. And so some of your emails and some of your efforts are reflected in that exhibit, that email chain, right?
That's correct.
And so could you just tell the judge kind of briefly what you did once we were looking for the videos?
I reached out to Barcom. I submitted a ticket, which is how we request assistance, and asked them to see if they could look through the Exact Vision server and find any video that may have been purged and see if it was recoverable on the date in question.
Okay. And could you describe how that server works just briefly to the judge? It's sort of, it's running, is that camera running 12 hours a day, 24 hours a day?
24 hours a day. That server, it operates not only the holding cell camera, but the camera inside the patrol room, the cameras in City Hall, and our parking lot and public works yard. So the server runs 24 hours a day. And so as new information comes in, or new video comes in, old video falls off.
And so it's your testimony that this thing is running. As it fills up, the old videos are removed to make room for the new videos.
They are purged from the system to make room. Yes.
Okay. Is there anything else that I forgot to ask you that you think it's important the judge to know?
No, sorry.
Is there anything else that I forgot to ask you that you feel like it's important for the judge to know?
No, sir.
I passed the witness, Judge.
Deputy Chief Pruitt, the description of how the server works that you just gave to the state, is that from your personal knowledge?
Yes.
Okay, so what training, background, experience do you have in technology or servers? And
I don't.
Okay, so how did you ascertain personally how that server works?
That's how it was explained to us when it was installed
So,
in 2014.
okay, so that was my question. Your testimony you just gave is based on what somebody told you, correct?
That is correct.
Okay. And who was that told you that?
It was 2014. I don't recall.
Okay, now, are you aware, and maybe I asked you this before, that the prosecutor, Mr. Wilkins here, upon his first request for video of the holding cell area, the response from your department was, there is no camera there. Are you aware of that?
No, sir. Where was that response, if I may ask?
Okay, well, I'm part of the state. I just wanted to know if you were. I just wanted to know if you were aware of that.
All right, everyone, please keep your voice up because everyone starts with their voice this level and then you trail down and lower your voice, and it makes it difficult for the court reporter to hear and for me to hear.
Certainly, I feel like I'm yelling in her ear.
No, you're not yelling.
Okay, so so that wasn't true. If somebody told if somebody told the state from your office that there was no video recording equipment in that area, no videos taken, that would not be the truth, correct?
That would be correct. There are videos that the cell and the patrol room are video recorded.
And why is it that you record videos there?
Primarily, it's an observation. Our dispatchers monitor the cameras, just like they monitor the city hall cameras and the parking lot cameras, in case there is a problem with a prisoner.
And those videos are saved, or at least still accessible for some period of time.
That's correct.
And do sometimes defendants make confessions on those videos that you can then send to the prosecutor?
Our confessions are recorded on our body worn cameras.
Okay, if have somebody in a holding cell, it would, and they confess there, it would also be captured on the video above the holding cell, correct?
I suppose it would be the microphone is not a very good one.
In fact, that brings me to my next question. Is the device that takes the audio down the same device that records the video?
I do not know.
Okay, because there is still in existence audio from the day of Mr. Sanchez's arrest, just not the video, correct?
It's my understanding that some audio files were recovered, but they are almost incomprehensible. You can't understand what is being said.
I would agree. I've tried and can't hear anything. So that's, so you don't know if there's two separate recording?
No, sir, I do
devices?
not.
Okay, so we would probably be better off asking those people that we've spoken about
Well,
today, correct?
Big State Electrical, from my understanding, Big State Electrical is the one that installed the exact vision. And that is part of Barcom's contention, is that they are not the subject matter experts on the exact vision.
Electrical companies install servers, but they don't understand how servers work, correct?
Not any more than I do, probably.
All right, okay. At this time, Judge, I don't have any further questions.
All right, any further questions?
No questions, Judge.
All right, I have a couple of questions. And counsel, I believe you'll be able to answer when the video was requested.
The video was first requested. Judge, let me put this file down. I've got a bunch of
Sure.
stuff.
I have June 22nd.
That sounds about right.
What date?
June 22nd.
And is that June 22nd of 2023?
Yes, ma'am.
All right, and that's what I have on the docket sheet. Now, when was it purged? Do we know the date or not?
That's what the court was trying to find out. For some reason, we can't seem to get to the bottom of that. It's a very simple question.
And will the persons who are going to be subpoenaed, would they know when the video was purged?
No, ma'am, I've asked that question repeatedly, and they say there is absolutely no way to determine that because of the way it operates.
Okay,
My understanding, Judge, is when you first requested the video, they couldn't get anything before March 12th of 2023 off the server.
That's correct.
So it's not as if I don't think there was any on purpose erasing or keeping over or anything. I believe my understanding of the way the server works is it's kind of running all the time, 24 hours a day.
And I don't mean to be.
so we'll need to have that witness come in to testify to that. So the video records that we are seeking, and I say we, but that defense wants, is that the videos for prisoner cell 1 and 2?
Yes, sure. A holding cell, yes. I guess it's like a cage.
It's a holding cell.
Okay.
All right, holding cell 1 and 2. And you're stating that the video from holding cell 1 and 2 has been purged.
That's correct.
The audio, is there audio in holding cells 1 and 2?
My understanding that they're, you mean all the time?
Yes.
All the time, yes.
All right. The audio from holding cell 1 and 2, is that, do you still have that or was that purged?
It's my understanding they recovered some and it was given over to the court.
All right. And when you say recovered some, is it recovered some of Mr. Jose Sanchez?
It's hard to tell. because
Interaction?
It's audio only, not video. And the audio, from what I understand, is you can't understand what's being said.
All right. No, I understand that. But the audio, is it the audio that would have been playing or recording when Mr. Sanchez was in holding cells 1 and 2?
Was recovered, the audio that was recovered was during the time frame that we requested.
So the only thing that has been purged is not the audio, it's the video for holding cell 1 and 2.
From my understanding, it was all purged, but they were able to recover audio only.
Okay, no. I'm off the audio now. I'm back
Oh,
to video.
I'm sorry.
That's okay. So my understanding is, and I just want the record to be clear. The video from holding cells 1 and 2, when Mr. Sanchez was there, has been purged, destroyed, cannot be recovered.
That's correct. ma'am.
All right. And other than the video and holding cell 1 and 2, counsel, is there any other video that may have what you're looking for?
Your Honor, I was informed through this process that there is also a camera in the office adjacent to holding cell 1 and 2. I did not ask for that because I was not aware of it, and I will offer for the record, and maybe we can put this on the record, that the reason I wasn't is on my first request, I was told through the state by the Alamo Heights Police Department that there was no recording devices, that they did not record and record.
All right, Deputy Chief, do you know whether or not the camera that's adjacent to holding cells 1 and 2, if there would still be a video available during the time that Mr. Sanchez was there, or has it also been purged?
I can say that it all operates on the same system. It would be my assumption that it was purged, but I can ask them to look.
All right, if you'll ask them to look into that, and then what we will do, the parties who are not here, we'll place them under subpoena and let them know they will not be allowed to appear by Zoom. They were given a chance to appear by Zoom, so they will have to come to Bexar County 187 District Court and appear in person.
Yes, ma'am.
All right. Is there anything else of this witness?
No, Your Honor.
All right. Thank you so much for coming down. I
Thank you.
appreciate it.
Your Honor, if I could, because I don't want to, I think it's important for the future record, and I don't want to ask the prosecutor to be called. Can we agree that your first response from the Alamo Heights Police Department was that there was no recording?
Yeah, so, sorry, Judge.
Well, let me ask you this before he goes on the record. Is that in Defense Exhibit number 1? That's been tendered to me, the emails?
I believe.
So what the detective emailed back to me is the only video available is what was uploaded. The suspect was never interrogated.
All right. So is that in Defense Exhibit number 1, that conversation?
I don't know, Judge, because it was actually provided by the state. It's not, one of the things I was going to ask before we leave is that all emails concerning this subject matter with any member of the Alamo Heights Police Department or the city of Alamo Heights be turned over to the defense, because at this point, I think it's necessary to get to the bottom of this.
I don't think it's in here, Judge.
Okay. So if you'll get that email and then the court will review that. Now, with regards to the witnesses that need to be subpoenaed, when will they be subpoenaed?
I can do that this week, Judge. I've got to get my investigator to go out. I don't mind doing it, Judge. This is not a civil case. I really believe they have an obligation to have that very simple question of how that server works. I've been doing this a long time. I've never had any agency not be able to answer that question.
No, I understand what you're saying, but they want their subpoena.
Sir, to answer your question, Judge, I will do that tomorrow. I can't do it today, Judge, but I'll do it tomorrow. And I'll
No,
get that
that's
to you.
fine. What date would you like to come back?
May I just look at my calendar?
Yes. And we will get to the bottom of everything. All right. And those witnesses are to appear in person. Yes.
And Your Honor, as far as the emails, I know there's a lot of them. I don't think they're privileged. I don't know. I think I can bring a formal motion, but it might help for the record.
Well,
if they could read it.
Here's the thing. The state will review it.
Okay.
And if it's something they feel like they should not give you, they will let the court know.
Okay, that's fine. I trust this prosecutor. I'm just trying.
Yes. All right, Mr. Sanchez, we're to come back on October 19th to finish up this hearing. And state is offering into evidence State's Exhibit number 1. Any objections? It's an email.
No, Your Honor.
All right, State's Exhibit number 1 is admitted.
Judge, for the record, I also emailed State's Exhibit number 1, forward that to defense counsel in a couple months.
All right.
Yes.
All right, we'll see you all then.
Thank you.
You're welcome. All right. Court is calling 2022 CR 10642, State of Texas. Well, let me ask you this. Have you conferred with the state on the bond and you all can't agree?
I did confer. I don't know if I got a disagreement necessarily. I just told them what I was going to ask for, so I don't know.
All right. Do you all want to confer to see if you all have an agreement on the bond? I still need to have a hearing on it, but if you all have an agreement,
I think we're probably gonna want you to set it, Judge.
okay. All right. State of Texas versus Jose Sanchez. Could I have parties re-announced for the record for the state
Hank Wilkins for the state, Your Honor.
defense?
Eric Baker for Mr. Sanchez, Judge. please.
All right. And are you Jose Sanchez?
That's fine.
All right. There's been a request for a bond reduction hearing. Is that correct, counsel?
Actually, Judge, the motion to set a bond.
Motion to set a bond?
Yeah,
No
there's
bond
no-
has been set?
No bond has been set, Your
All
Honor.
right. So are there any witnesses?
Your Honor, I'll call my client, but just, I want to summarize for the court, what we're going to be asking for and why. I've discussed with my client his finances and, his ability to post bond. He is indigent. He has local ties to the community. He's lived here all his life. He was employed when he was arrested. He has that employment still available for him if he gets out. If the court sets a bond in the amount of $10,000.
Sorry,
So
Diana.
my client's also being very helpful with the court and it's.
Oh, I'm gonna make note of that for the record, that he's helpful. You can continue.
And so we're asking to set a bond in the amount of $10,000 if the court's so inclined, and if not, as low as possible, if it sets it above $10,000. And I can put that's just an offer of proof. If the court wants me, I can put my client under oath and ask him those questions to establish those things if the court finds it necessary. To establish those facts if the court finds it necessary. Advice, that's my offer of proof.
All right, state.
Yes, Your Honor, I would like to, I've showed this to defense, but this is the defendant's criminal history. I'd like to offer that as State's Exhibit 1.
There's no objection.
Oh,
And then you can see from the criminal history judge and from the indictment that the defendant is a habitual offender judge. So the state does believe that based on his history, based on the facts of the case, that $10,000 is too low of a bond, Your Honor. He is looking at, because of his status as a habitual offender, he's looking at 15 years, Judge. So we're looking for a higher bond amount than what's been requested by defense. We are asking that if you were to grant a bond in this case, or when you grant a bond in this case, we're asking for a full house arrest GPS. The facts in this case are that the defendant is driving around without he knows he's not supposed to have a firearm, he's got a gun in the car, Judge. So in order to protect the community, we ask you to take the GPS as a step to protect the community.
Can I respond? briefly
Yes.
to number one, Your Honor? It was a felon in possession. It's not been established that he knew the firearm was there. That'll be established at trial. It wasn't a violent offense per se. Number two, Judge, he actually was out on bond in this case for almost a year. And then his bond's been dropped him because of the parole issue. So he's demonstrated he's not a flight risk.
so here's the court's question. Does he not have a bond because the bondsman issued a affidavit to surrender surety? Is that the reason?
Yes, Your Honor.
So before the bondsman did that, what was his bond set at?
He tells me 20,000. I haven't independently verified.
All right.
2022 CR 10642. Your Honor, would ask the court to consider that although it was at 20, based on the 7 months he's been waiting for the state to answer a very simple question that it should have had the answer to in 1 week. I'd like the court to consider that in light of the fact that he may not be able to make a $20,000 bond, and in light of the fact that he's expressed a desire to get out so he can work, so he can afford his own attorney, he would like to hire an attorney. And secondarily, if the court is going to do GPS, I would request that the court allow him to work on that GPS monitor, because that's the main reason he wants to get out, so he can hire private counsel, and he'll need to do that quickly with a trial date in mid-February.
All right.
Judge, respectfully, can I respond to that?
Sure.
So the defendant claims he was on his way home from work when he had the gun. So that's why we're asking for the GPS, Judge. It seems like he uses the gun for work sometimes. So if you are inclined to grant a bond, we ask for full house arrest GPS.
If it is going to be partial where he's allowed to go to work, we'd ask for set times, Judge, so it's not just like, oh yeah.
We'd have no objection to that. He could provide proof.
All right, so everybody it's whispering a little bit, which makes it difficult for the court reporter. So people are starting with their voice here and then it immediately drops. So if everybody could keep their voice level for the court reporter, that would be greatly appreciated. Let's try to make her job as easy as possible.
And it's the state's
See,
fault.
Dinah?
I was just bringing it to his level.
Yeah. But Dinah, I'm always thinking of you. All right, so I have a question for you, sir. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record, and keep your voice up.
Alfredo Sanchez Jr.
All right. So, have you ever used any type of drugs before?
Yes, ma'am.
And what would that be?
Methamphetamine.
All right, when's the methamphetamine, marijuana, anything else? All right, before you were taken in custody, when's the last time you used a drug?
7 years. I was locked up for 5. So I got out and I was out for about 1.5 years.
All right, have you ever had treatment for those issues before?
Have I ever treatment?
Yes.
No, I've never been to a rehab. No, ma'am.
Have you ever had any mental health issues?
Yes, I've been diagnosed with manic depression and drug-induced schizophrenia, and then I forget what the other one was.
All right, have you seen any type of doctors? Have you seen a psychiatrist or had a therapist?
The only thing I've done is here, I've done recovery and motion, and in the world, I haven't done anything. I've never been offered that, so never done it.
All right. So the clerk has informed me that his bond before the bondsman got off his bond was $10,000. So unless there's some other reason for his bond being revoked, like for example, if he didn't show up for the court or something of that nature, I don't see why his bond shouldn't still be the $10,000. And that's based upon the fact that there was another judge who found that $10,000 was appropriate, and that's what they set it for. I would consider increasing his bond if there was a reason other than the bondsman joining an affidavit to surrender surety. But so I'm going to keep the bond at $10,000. I am going to order partial GPS. And that's for employment only. And you'll need to provide, your employment address. You need to provide what the hours you're working. You understand?
So I'm a member of the local 66 Iron Workers Union.
Mhm.
So I show up there to the shop at 7 o'clock or by 7.
You'll need to give that to them.
Yeah, I'll get an itinerary.
And then I'm going to order outpatient treatment as a condition of probation. I'm sorry, as a condition of bond. I'm going to ask that the fees be waived. And I'm going to also order mental health treatment. And that will be waived fees on that. Although I don't think they have fees for that, but I'll just put that in there. All right. And I want you to know the reason why I ask the questions I ask, because legally we're supposed to do that. So I can figure out what conditions to give you so that you'll be successful when you're on bond. You understand?
Yes, ma'am.
If there is something else that comes up where you feel you need more help with something, be it drug treatment or mental health treatment, let them know. If you feel like they're not addressing it, you can always come back to the court. All right, and we'll do random UAs.
My family already went and spoke to someone at Lifetime Recovery.
Okay, well, I'm going to ask that the fees be waived, and if it's Lifetime Recovery that you can get into Lifetime Recovery, just have your attorney let the court know, and I can change these conditions to include Lifetime Recovery.
Thank you, ma'am.
All right, so Norma, if you can give him a reset form for his case. And if you'll give this to the court reporter, is there anything else from either side?
No, thank you so much, Judge.
All right, you're welcome. 2022 CR 10642, Jose Sanchez. All right, so where we were is whether or not the state is objecting to the removal of the GPS. And state, you're objecting to removal?
Correct, Your Honor.
All right, and what is his criminal history? Is there anything in his criminal history other than the deadly conduct firearm that was in the
The only other assaultive things, Your Honor, I mean, his history was drugs and, theft type things, other than what you mentioned with the deadly conduct firearm. And then he has priors that include family violence assaults. He has two that resulted in convictions on his record. He has one in, I believe, 2003. And I believe the other one was, and Mr. Edelman can correct me if I'm wrong, I think it was 2014 or 13, something like that. 13. So
those misdemeanor assaults?
The first one was a misdemeanor. The second one started because it was a family second and he had the prior conviction. It started as a
Okay,
felony.
you need
and
to
it
slow
went,
down so the court reporter can keep up.
it started as a felony and then it ended up as a misdemeanor. So
And when I say so the court reporter can keep up, she was keeping up, but why would we make her job more difficult than it needs to be? So,
I will talk slower.
thank you. So two assault cases. One was the misdemeanor.
One was a misdemeanor, the other one started off as a family second,
Mhm.
and then it got reduced to a misdemeanor as well.
Okay. All right.
Your Honor, may I add a bit of more information?
Yes.
Not the assaults that concern me so much as Mr. Sanchez's compliance on pretrial supervision in his evading arrest with a vehicle. When he was released on bond, he eventually accrued 4 pretrial violations that resulted in a bond increase, which became somewhat irrelevant when he failed to appear for his trial date. On his most recent case, he had a bond for which his principal asked to be released from it because he did not comply with his bond agreement and stopped reporting to the bonds.
And if I may speak to that, Your Honor, first of all, I think the evading arrest that Mr. Edelman was speaking of, obviously those cases occurred when he ended up on his parole and then he was on parole. The current one, it's my understanding that it wasn't that he wasn't, and I don't know what the bondsman may have put on there, but he was compliant in the sense that he ended up in custody. And I think that was why he ended up going off the bond, was that he ended up in custody with the parole hold. I will also say that since being on bond, he has, and he actually wanted me to mention, to thank the court because part of his release on bond included the court sending him to lifetime recovery. He successfully completed lifetime recovery and he believes that now he is really on a track for the first time in his life, although he went through all of these other types of probation and parole, but there was not a program that he felt helped him as much as the lifetime recovery program. And now he is trying to very much so step up even with his children. There are children that, yes, as the court heard, there are older children that have really struggled because they haven't had a father in his life because he's been in and out of the legal system. He is now even seeking out to help a couple of those older boys as much as he can with some of the stuff they're going through and using funds from his job to try to do that. So really, and if you look at how he's been doing on his pretrial for this case, after successfully completing that program, I don't believe he's had any violations. He said that there's been a couple times because of work or his ride getting home, he has ended up slightly late, but barely with his monitor. And every UA has been clean. And he very much so wants the chance to just be, for the first time in his life, a productive individual and a father that he feels like he hasn't been able to be until now.
All right. This is what the court is going to do. As previously stated, the court is finding you guilty. The court will sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $1,500 fine that will be probated. 150 hours community service restitution. The court is going to require parenting classes. Once you complete parenting classes, the community service hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There are going to be field visits 1 time per month for 4 months. And I will do GPS partial for work for 2 months, and then tracking only for 1 month. And after that 3.3-month time period, if there are no violations, let probation know, and probation will let me know, and I'll remove the GPS. Probation, there is to be regular random UAs. And probation, is there anything else he needs?
A probation monitor.
All right, so here's the thing. Probation monitor. I can't waive fees. I can sit up here and say I'm going to waive fees, but it's not going to be waived because it's a third-party contract and I can't make them waive it. Otherwise, you can end up with a GPS, but it'll be the GPS that you have to pick up at the jail. That one, fees can be waived. But with that one, if they give you a time schedule and appointment, you've got to be there at that time schedule and that appointment. If you miss that appointment, what's going to happen? You're not going to have a GPS device and a warrant may be issued for your arrest. So normally GPS is $300 a month, I think. The one at the jail, I can ask that the fees be waived on that one, but you need to make sure you make that appointment. If you don't make that appointment, there's like no excuses, right? All right, so I'll give him, because he needs to make a schedule with the jail probation. Is that correct? Can we do that?
No.
Oh,
I just let him know. I mean, you just tell me when he has to be there.
all right. So what we'll do then, because they're going to want that monitor back very quickly. What's your work schedule?
My work schedule usually is from 7 in the morning till 5 in the afternoon, but if you,
No,
whatever,
I mean, what days? Is it Monday through Friday?
Monday through Saturday. But my boss he'll work with me.
All right. Well, since you were here today, Friday, is that okay? Probation or Friday?
Friday.
What time on Friday?
Can you get to probation by the jail?
Yeah, I can be there in the morning if you want, afternoon, or whatever. time.
Oh, what time are they open?
You can go like at 6 a.m., right?
I think.
8 o'clock in the morning.
Yeah, I would say 8.
All right. So then if you get there at 8 o'clock, you'll probably be the first one and you'll be able to have some time at work.
It will take about 3 hours for install.
What's
right.
their address?
The probation will give you the address. So you'll need to have the GPS exchanged on Friday, July 26th by 8 a.m. And I say by 8 a.m., you just need to be there at 8 a.m. for the appointment. And I'll ask that the fees be waived. All right, you're welcome. Yes.
Was gonna ask a question about the mental health that you sent me to.
Mhm.
They gave me a diagnosis and I was wondering if there's a way I could get some type of information from them because my wife wants me to.
Sure. Was it through the Center for Healthcare Services? All right, I'll refer you back to the Center for Healthcare Services and they should still be able to help you. If not, just let probation know. And if they're not doing it, just come back to me. Okay.
Thank you.
So we'll continue with the referral to Center for Healthcare Services. Is there anything else you need from the court? Probation, is there anything else?
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes, sir.
Because this is plea bargain agreement, because You waive your right to appeal, and because I followed your agreement, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. So I read the police report, and I will tell you what your mother said in that police report is the same thing that my mother always said to us and that my grandmother always said to them. I love you, but I'm not going to jail or prison for you. And that's what your mom said at that's what my inside chuckled for, because it was bringing back memories with my mom saying, I love you, but I'm not going to prison for you. I'm not going to jail for you. So I admire your mother for showing up and saying, I'm not going to jail for you. So, and don't ask your mom to do that, okay? All right, good luck to you. And thank you so much for dressing appropriately for court. And if you complete everything early, come back, but do not come back to court before at least 2 years have expired. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you,
And
Judge.
probation will go over conditions with you.
Thank
Your
you.
Honor.
Thank you, Judge. Have a good day. May I be excused?
Yes,
Have the excuse.
yes.
Thank you.
All right.
Your Honor, and I'm sorry to say that.
Thank you very much. Have you attempted to reach him this morning?
I have not done that, Your Honor.
I thought you told my bailiff that you attempted to call him this morning.
Not this morning, Your Honor. So I'm sorry if I indicated that. No, that was.
Do you have a good contact number to call him?
I will check, Your Honor.
You know, Mr. Heasley, if your client, and that happens fairly frequently, when your client fails to appear and you have contact information, you shouldn't have to wait for the court to tell you to call him.
Yes, sir.
I mean, you've been doing this long enough to know to get on the phone and call him even before we go in the courtroom. Don't even worry about it. He's not here. I'm revoking his bond. I'm issuing a warrant for his arrest. No bond will be imposed on that warrant. We'll reschedule anything in this case until the defendant is incarcerated and the warrant is executed. You know, for the benefit of your client, you may want to do that in the future, but too late now. I'm revoking his bond. I'm issuing a warrant.
And, Your Honor, I don't see a phone number in our contact information for what that's worth. So, on the issue, thank you. Thank you.
Anything further, Mr. Lewis?
Oh, no, Your Honor, thank you.
Okay. Okay, this matter is concluded. I'm sorry that all.
Mr. Garvin, have a seat.
Court's back on the record. City of Conneaut versus Keith Garvin, 25 CRB 91. Mr. Garvin comes strolling in at 9:25 a.m. Case is set for 9 a.m. Where you been? Excuse me? Home. Take him into custody, hold him, and then we'll make you think about being on time. Seriously. We're revoking your bond. Tired of people being late. I've got a full docket today. Full docket. You knew you were supposed to be here at 9. Okay, the court is back on the record in City of Conneaut versus Keith Garvin for the third time. Case number 25 CRB 91. The court instructed Officer Pinkett to bring Mr. Garvin back up from the jail so we can proceed with today's hearing and pretrial conference. Mr. Garvin is present. He's accompanied by his attorney, Philip Heasley. Also present, Law Director John Lewis and Officer Pinkett sitting at the Law Director table. Mr. Garvin, does your attorney know how to get a hold of you? You left him 4 different voicemails? Does he have your phone number? Write your phone number down. You got it?
Yes, sir.
Okay, that's good. Because earlier, a few minutes ago, Mr. Heasley reported he did not have contact information for you. So, when did you leave these 4 voicemail messages?
I believe the first one was the day after court.
You guys even have voicemail at the public defender's office?
We have voicemail, Your Honor.
I'm not even gonna get into that,
Okay.
you know, if this is true, because now I'm really steaming. Why were you late today?
Thought we had 10. I thought I was here 30 minutes early.
Yeah, well, I've got a signed receipt in the file showing that you signed a receipt with a 9:00 a.m. hearing date, or hearing time. So, you were wrong that it started at 10. Okay, counsel, have you guys talked about possible resolution, or are you ready to proceed with the hearing on motion?
I'm ready to proceed, Your Honor.
Okay. Mr. Heasley.
Thank you, Your Honor. We have just been provided with information regarding the revocation
What do you mean just provided?
earlier this morning from the prosecutor, Your Honor.
Well, you knew this hearing, you knew today was also scheduled for a hearing on the revocation though,
Yes,
right?
sir.
Okay. So you're talking about like discovery information?
This is on an alleged incident from April 20th.
When I ask you what were you provided today with, is it discovery information about the revocation issue?
Yes, sir.
Okay. So what are you asking?
And I do realize the court has its schedule a minute or two to speak with Mr. Garvin regarding the revocation and whether he would admit to the same. And if not, we're prepared to have a hearing. Thank you.
Response to any of that, Mr. Lewis? So Ms. Martini didn't testify, and she's in the courtroom today. Ms. Martini? Which one is Martini? Ms. Martini, the evidence offered by Mr. Lewis through the police officer indicates that you were together with Mr. Garvin on April 28th, 2025. And the text message or email, I should say, more or less indicates that you were a willing participant in this contact.
Yes. He asked me to bring dog food, and I did. And the only way that I was able to leave, he snatched my keys out of the ignition. The only way I was able to leave was if I took him wherever he wanted to go.
So you literally went to pick him up to get dog food?
No, he took a different picture of the emails. I told him to either leave the money or I'll just bring the dog food. And he said I'm not, or leave the door unlocked. And he said he wasn't doing none of that. So, but yes, I did go to the house, and that's when he got the keys, and he told me, or he said, you can't leave unless you take me wherever. Which I did have to take him to work, because he wouldn't let me leave. He wouldn't give me my keys. I actually had to take him to the store, to work, back to the house, and he tried to get me to take him back to work. But that's when he told me that he was gonna come up here and make a police report if I didn't take him back to work. So then he called a friend to pick him up to bring him up here.
Why dog food?
Because we have a dog there and he doesn't really take care of animals. So
you have a dog together?
Not together, but I do. There is a dog at the house.
At the house he's at?
Yes.
Okay. I mean, Mr. Garvin signed a bond on April 7th, 2025. It's in bold print. It says that he is to have not consumed, possess alcohol or drugs, subject to random chemical testing, no contact with victim Tony Martini. I mean, no contact means no contact. I do find the defendant has violated the conditions of his bond by having contact with Tony Martini. So what would you like me to do, Mr. Now that I found that he's violated the condition of his bond?
All right. Vote the bond and place Mr. Garvin into custody. I mean, this is an ongoing situation, as the court is aware. Ms. Martini has informed me that she's filed an eviction proceeding against Mr. Garvin. The house that Mr. Garvin is residing in belongs to Ms. Martini. It's just an ongoing issue. And I believe, well, I didn't have Ms. Martini testify in interest of moving this proceeding along because I understand the court stopped in slam today. But Ms. Martini told me previously that these emails have continued from Mr. Gardner to her beyond April 28th. I think that
We hope that, although it is in the court's discretion to do that, we would hope the court would not. The court itself, although Ms. Martini, as Mr. Lewis indicated, did not testify, the court did elicit information from her directed towards the bench, and that only confirmed the fact that she was involved in the contact as well from her end. That is not uncommon in these types of situations. There are personal ties between the two. And I would fully agree, as the court said a few minutes ago, that no contact means no contact. But Ms. Martini, in response to your own questioning, did indicate her role in this. Mr. Garvin must not have any more contact with her, either personally or by any other means, with Ms. Martini here. And I'm sincerely hopeful that that will not happen, and we will have a repeat of this type of incident pending the resolution of the underlying matter. I believe that the officer was asked if there was a repeat incident similar to this one on April 28th, and I do believe he indicated not to his knowledge. We would hope, Your Honor, that Mr. Garvin would not be taken back into custody. He does work. He must leave this woman alone and abide by not just that element of the court's interim orders, but also every other element thereof. So we would hope that he would not be taken back to jail over this, Your Honor. That's all. Thank you very much.
Thank you. This incident happened on April 28th. Ms. Martini, have there been any other contacts since April 28th?
Yeah,
How?
I don't know.
So he's emailing you?
Yeah, and I called and I reported it. I talked to Officer Kiesling and she had me email pictures.
And do you respond to those emails? I mean, is this a
I
communication?
haven't, no.
What don't you get about no contact, Mr. Garvin?
I should tell my attorney she broke the no contact with the day.
Yeah, well, she's not ordered to have no contact with you. You're ordered to have no contact with her.
She came in the house the day after court, the initial hearing. I told Philip that. He didn't want to bring it up. He didn't want to have an attitude like we have right now.
Yeah, I've got an attitude because you were a half an hour late. That's why.
That's my fault. That's why there's no contact. She walked in the house. Walked through the back door. I told her there's no contact with her, bro. This is my house. I can do what I want to do. This is the 8th.
Well, you know, an eviction, civil, that's a civil matter. And I'm going to be the one having to make a decision on that at some point if that ever comes to before me. I don't want to get into that. And nor do I want to use the criminal process to assist an eviction. Because I've been confronted with that in the past. Look, Mr. Lewis mentioned it. And Officer Pinkett knows full well that our jail is overflowing today. And Mr. Garvin, no contact means no contact. You don't seem to understand that. You're just like questioning, you know.
No, you said no contact. I just told you the day after our original.
I'm telling you, you're to have no contact with her.
She walked in the house. What am I supposed to do? She walked to the back door.
Well, you need to call the police.
Okay.
You need to call the police. And I don't know about these emails. I'm looking at an exhibit of emails clearly showing contact by you outside of her coming into your residence. If you have one more, any bit of contact with her while this case is pending, Mr. Garvin, I'll revoke your bond, you're going to jail, and I don't care. I'll stack you up in bunk beds on top of each other in a jail cell. I don't care. If it happens one more time, that's where you're headed. And Ms. Martini, you need to call the police if there's any further contact, and you need to stay away from him. Understood? We'll set this case for a final pretrial conference in the near future. Bond will continue as previously set, although I am finding that he did violate the conditions of his bond, and I will make clear that if it happens once more, we will revoke it and he'll go to jail.